This news just in, a delay in the second criminal trial of Trump's former campaign chair, Paul Manafort. A federal judge in Washington has just postponed the opening arguments by nearly 2 weeks. Manafort faces charges including conspiring against the United States, money laundering, and witness tampering. All right, it's been months since presidential lawyer Rudy Giuliani told NBC News that special counsel Robert Mueller's team has acknowledged it cannot indict a sitting president. But Trump's former personal lawyer, Michael Cohen, alleged in federal court last week that then-candidate Trump directed him to make or arrange hush money payments to women, saying it was in hopes of influencing the 2016 election. So I want to take a look at where this supposed immunity from indictment comes from for a sitting president. The United States Constitution lays out a way to remove a president from office, impeachment, but it is silent on the criminal prosecution of a president. Remember, impeachment is something that takes place in Congress, not in the courts. In 1973, at the height of the Watergate scandal, the Justice Department's Office of Legal Counsel, or OLC, issued an opinion that criminal proceedings damage the president's ability to do his job and shouldn't be brought while he's in office. Another OLC memo, about 27 years later, reinforced that original argument, saying the indictment of a sitting president would undermine the entire executive branch's function. But federal guidelines allow for something called extraordinary circumstances, allowing Mueller, if he found such circumstances, to request a pass from the Deputy Attorney General, Rod Rosenstein, to go against policy and indict the president. That, barring something truly earth-shaking, is unlikely. But consider this. These memos and guidelines, according to the OLC website itself, provide, say that they're there to provide legal advice to the president and all executive branch agencies. So outside of the executive branch of the federal government, there might be another way to do this. An office with the power to bring an indictment could feasibly bring one against the president. That's according to Yale law professor Ona Hathaway. An office like a state attorney general, for example. New York's Attorney General Barbara Underwood, whose office is currently suing the Trump Foundation for, quote, persistent violations of state and federal law. Joining me now is Ona Hathaway of the Yale University Law School, because I figured let's bring you in since you've been writing about this. Great to have you here. Explain to me the way in which a state attorney general like Barbara Underwood or like Joshua we just had in here might work around this prohibition or this guideline against indicting a president.
Yeah, so as you mentioned, the Office of Legal Counsel memos are binding within the executive branch, but they're not binding on anybody else. And so a state attorney general, for instance, could bring charges against the president while he's in office and would not be prohibited from doing that by the Office of Legal Counsel memos.
And I would assume at that point the government would be in court and a court would have to decide. And why wouldn't the government point to this Office of Legal Counsel memo in which it said the indictment of a criminal prosecution of a sitting president would unconstitutionally undermine the capacity of the executive branch to perform its constitutionally assigned functions. So while Barbara Underwood or a state attorney general wouldn't be bound by that guidance, would the government's argument not be the same?
It would be the same. Certainly it would. And they would certainly point to the Office of Legal Counsel opinions and say, look, you know, this has been decided twice by previous administrations, but that's not binding on the courts either. So the courts get to reassess the question on their own and decide whether they agree with the Office of Legal Counsel determination on this question. Now, you have to remember the Office of Legal Counsel lawyers are effectively the president's lawyers.
Got it.
Right? So they're making a decision for the executive branch, and they are looking at the law and they're trying to render their best opinion, but they are acting as executive branch lawyers. So a court is going to come in with a more objective position. It's going to look at all the law and the facts and make a determination in that case as to whether to let the case go forward.
In the article that I read that was so interesting about this, you make a point that whether or not this is likely, it's more likely or more reasonable a thing to consider than impeachment?
Well, so the problem with impeachment is just it's really hard, right? So you have to get a majority of the House. Right now, of course, that's Republicans,
right.
So they're not going to impeach. Even if the House switches to Democrats and Democrats do impeach, you have to then go to the Senate for conviction. In the Senate, you have to get 2/3 of the senators to vote in favor of impeachment.
Right. It's like a constitutional amendment.
That's right. And it's extraordinarily difficult. It's hard to get 2/3 of senators to agree on anything. And impeachment is just so explosive. It's hard to imagine that would happen unless something much worse comes out. And that's always possible. So, never say never.
Yeah.
But it seems unlikely at this moment.
Hey, MSNBC fans, thanks for checking out our YouTube channel. Subscribe by clicking on that button down there and click on any of the videos here to watch the latest interviews and highlights. You can get more MSNBC for free every day with our newsletters. Just visit msnbc.com/newsletters to sign up now.